debtor should be able to state that in the disclosure statement. The allocation formula was disclosed in Purdue Pharma after several iterations of the disclosure statement. And I don't think we should be hearing that from third parties informally. I think that is a critical piece of information to explain that this percentage was not just pulled out of thin air, to understand the purpose behind it, how it was calculated, and to allow us to test the accuracy of that in terms of the inputs that they used and whether we agree with those. Because this is, as they said, ultimately a confirmation issue as to whether the allocation method is proper and fair. And we just want an adequate opportunity to understand and test that as we approach the confirmation hearing and go through the confirmation-related discovery.
Mr. Gott?
Your Honor, I think you just really heard the key point, which is that the rationale behind the proposed allocation is a confirmation issue and is something that will be tested in the discovery process that we have teed up for confirmation. And at confirmation is the appropriate time to tackle the propriety of the allocation. Like I mentioned, and to echo the comments of Mr. McClay and Mr. Eckstein, it is certainly not unprecedented, and indeed is more and more common in other mass tort contexts for specifics around procedures and the precise outcome for individual claimants to be disclosed as part of a plan supplement. And here, when we to use the phrase plan supplement is even somewhat misleading, because often I think when we think of a plan supplement, you think of something that's disclosed maybe 7 days before the voting deadline that just kind of contains some of the extra documents that go along with the transactions contemplated by the plan. Here we're talking about, like I said, 5 or 6 weeks with the documents at issue that will disclose what the plan will provide to these claimants and how those funds will be allocated and distributed and for what uses they can be deployed. So we think the time with that information is more than adequate, and so we think that this objection should be overruled.
I agree. I think it is not unusual in mass tort cases to have the TDPs filed later with the plan supplement, and I'm satisfied that the debtors are providing a sufficient amount of time between those disclosures and the voting deadline to allow the opioid claimants to review those and make a determination whether or not they think it is appropriate to vote for or against the plan. So I think the disclosures are adequate. I will overrule the objection.
Okay, Your Honor, the next objection in the chart that has not been resolved was filed by Attestor Limited and Humana Inc. at docket number 2384. There are a number of issues that at least to our understanding, are still outstanding, and so I would cede the podium to Attestor Humana's counsel to take us through their objection and hopefully flag those topics for us that we think are still outstanding.
Your Honor, I assume you can hear me. Matt Feldman for Attestor Humana from Wilkie Farm Gallagher.
Go ahead, Mr. Feldman.
Thank you, Your Honor. Your Honor, I think everything I'm going to say, Mr. Gott is going to respond that those are confirmation issues, but if the court will indulge me for just a couple of minutes, I think I'm going to explain why I don't think they're confirmation issues and why I do think they are disclosure issues. Your Honor, we have to really back up a little bit and understand how we got here today. We got here today through a negotiation pre-petition with the RSA parties, where essentially all of the value from the combined business was allocated to the opioid side of the house. And why would they do that, Your Honor? They would do that because, in fact, they didn't expect to file the branded business. And that made all the sense in the world. As long as they could, in the ordinary course of business, pay for the Actar business and the other branded business, then there was no reason not to take that value and move it across to the opioid settlement. But what happened in the interim is that the DOJ and CMS showed up. They brought legitimate claims for antitrust violations and other types of violations, lawsuits filed. And so the company, again, I think appropriately made the decision that they needed to file the entire company. but there was no value left available for Actar and its creditors and those claimants. And so as a result, here we are. They've put together a plan that in essence says, you'll take $30 million because that's all the value there is. The legal fees in this case and professional fees are going to exceed $30 million. So that number couldn't have been right. But they bumped it up to 100 and they said, go sit in the corner and be happy because the guarantee bonds have claims at all of the boxes and you don't. Well, we're going to find out, Your Honor, at least start to find out on June 25th if that's right. But of course, they want the disclosure statement approved today. So they want to go out with a plan that won't work if it's, in fact, the boxes don't work the way they say they do. And Mr. Harris, I think, said to you at the last hearing, Your Honor, that he'll take that timing risk. I don't understand why he has to take that timing risk. In fact, I'm not sure why we're going forward with the disclosure statement today. We're in the middle of a mediation with Judge Sanchi, which is, well, middle is a bit of an overstatement. We're at the beginning of a mediation with Judge Sanchi that has not had a chance to perform or work. But at the end of the day, if we're right, and we will demonstrate that at confirmation, that in fact value has moved, then this plan won't be confirmed. And by the way, if we're wrong, then there should be disclosure about it because we can't decide whether to vote in favor of a plan that allocates $100 million to all general unsecured creditors other than the government, other than the bonds, other than the opioid side, or whether we should vote to oppose it because there's no disclosure around that, Your Honor. In fact, all of that disclosure is going to have to come through a discovery process, which Your Honor knows and everybody else on the Zoom call knows has been and will continue to be a very difficult process because the debtors are not forthcoming with disclosure and are not forthcoming with discovery. So we think, Your Honor, there are really two paths here. One is that we ought to simply delay approval of the disclosure statement for 30 days, let some of these other issues ripen, including, frankly, on the opioid side, which I was not all that familiar with, which I'm hearing about this morning, or I'm sorry, this afternoon, but also let the court hear whether or not we are entitled to claims at additional boxes, which would change the disclosure. If we're not entitled to those claims, then maybe this disclosure statement can stand, or maybe it could be supplemented by that, and to let Judge Sanchi begin his process of mediation. If we go forward today, Judge, we are heading towards a confirmation war, not a confirmation process. And in my mind, it may be for no reason, but certainly we could understand and limit the number of issues that have to be dealt with at confirmation if the case had just progressed a little bit further. And so we would ask, Your Honor, that they either update the disclosure that relates to what value was taken from the Actar side of the house, the branded side of the house, and moved over to the opioid settlements. But more importantly, Your Honor, we would ask the court not to approve the disclosure statement today. You don't have to deny it today either, Your Honor, and give these cases time to ripen. So I'll pause there. I'm sure Mr. Gott's going to say, these are all confirmation issues, Judge. Overrule the objection, and we'll talk about it.
Mr. Gott?
Your Honor, to the contrary, certainly while the issues that Humana and Attestor have raised and that Mr. Feldman discussed will be disputed and will be litigated at confirmation to the extent they aren't litigated before then and resolved in the many turning wheels that are already in motion. I think the disclosure issue that's raised around the potential risks associated with the Attestor Humana litigation, their theories of their claims, and of potential bankruptcy related issues like avoidance actions, like administrative claims. Those have all been addressed with pages, frankly, pages and pages of additional disclosures that have been included in the disclosure statement. It's just starting on, I'm looking at this is the red line of the disclosure statement that was filed at docket 2865. This was earlier this morning, overnight. Starting on page 98, we have more than two and a half pages that were largely drafted by Humana and Attestor to explain their view of the cases and explain the risks associated with proceeding toward confirmation of this plan. So we think the disclosures around all of these issues are adequate and appropriate. And like I said, we do have we have a number of processes that are already in motion, that are already moving. We have the claims objection hearing coming up on the 25th. We had the discharge proceeding last week. We have the administrative claims part date coming up and litigation around AFTHAR administrative claims. And all those things will build and will occur, are intended to occur before the confirmation hearing or at the latest in connection with the confirmation hearing, when the pieces will come together and the debtors will carry their burden and prove that the plan is structured appropriately. So we think the objection as to the adequacy of the disclosures is unfounded, and we think it should be overruled.
What about what are the disclosures regarding the transfer of funds between the specialty brand side and the generics brand side? I think that's what Mr. Feldman's talking about.
Yeah, I know. I'm sorry, Your Honor, I'm not interrupting. We don't dispute that the risks associated with us being successful on the litigation have been properly disclosed. We think it's a shame to go forward, but that's a different issue. But there is no disclosure that I'm aware of, Your Honor, and it is a voluminous document, and they keep updating it and filing, to their credit. I am certainly not aware of anything that talks about the fact that value has been siphoned off from the specialty brand side to the generic side.
Well, my guess is they're not going to describe it as that it was siphoned off, but let me hear from Mr. Gott as to what he thinks the disclosures are in the disclosure statement.
Yeah, Your Honor, the piece that we've added, and we thought it was targeted at what was being raised by this objection, not just by Humana Attester, but also by the ad hoc ACTHAR group. The disclosure was added, excuse me, I believe it, let's see, it's Article 4, Section Z of the disclosure statement, and I can get the page reference. That's page 98 of that red line I mentioned before, filed at 2865. And the disclosure is that, and again, this was targeted to what we thought the issue was. It was that the ad hoc ACTHAR group has identified 14 billion of intercompany transfers that it believes may be subject to challenge and or avoidance. The debtor's position is that the transfers identified largely reflect ordinary course intercompany business activity and or satisfaction of non-avoidable obligation, the general structures of which are described in more detail in the debtor's cash management motion filed at docket number 23 in the Chapter 11 cases. So that's our summary of the issue and of our position on things. We, as Your Honor noted, we don't believe that there are actionable claims relating to any of the historical transfers at issue involving mallinckrodt ARD. But if there are topics that aren't addressed by that disclosure that we may have had a disconnect on, happy to consider further disclosures around the subject. But we think that level of disclosure explaining that transfers have been identified, the creditor, the objector believes that they may be avoidable, the debtors disagree. We think that's the level of disclosure that's really necessary here.
Your Honor, I think there are two things missing in that disclosure. One is the impact of us being right, that is missing. And secondly, Your Honor, whether or not they're continuing to take value or money from the ACTHAR specialty branded side of the house and move it over to the generic side of the house, whether that's part of their business plan going forward. People should understand that because there now is a stock option under the plan. So would you want to own, would you want to own this company if money is going to be, moved around as it has been historically? And that's not disclosed. Again, I'll turn to Mr. Gott, who knows his document better than I do, but certainly not disclosed anywhere that I've seen.
Your Honor, as the disclosure indicates, the flow of funds around the company is disclosed in some detail in our cash management motion, and the disclosure statement now specifically refers anyone reading that section to that motion to gain a better understanding, and then fundamentally, the validity of those transfers or whether any of them give rise to actionable claims are issues that will need to be sorted out in the confirmation discovery process. All
right. I do think the disclosures at this point are sufficient to give a reasonable investor the opportunity to determine or to understand that there's a dispute over these transfers. I don't think the debtors have to disclose what the results would be if they lose that dispute, because that would be giving disclosures about other potential plans, which is not required by 1125. So I think the disclosures at this point are satisfactory enough to allow a reasonable investor to make a determination on whether or not to vote for the plan based on the fact that these transfers occurred. There's a dispute as to whether the transfers are legitimate, and that will be decided at confirmation.
Thank you, Your Honor. And I'm not going to renew it at this moment, but we would urge Your Honor, as part of the overall hearing today, to consider whether this is an appropriate time to approve a disclosure statement. Thank you.
Thank you.
Okay, Your Honor, next, the next objection we have in the chart was filed by the Buxton Helmsley Group and Alexander Parker at docket number 2385. We believe we've addressed really the primary issue raised by the objection, at least for disclosure purposes, by disclosing that there is a dispute, particularly arising under Irish law around the propriety of actions taken by the debtors and their board. But beyond that, Your Honor, we don't think there are additional issues that require further disclosure, and any other aspects of this objection would be related to confirmation and should be overruled.
We hear from Buxton Helmsley Group. No response. All right, that objection is overruled.
Your Honor, the next objection on the list was filed by Covidian, excuse me, at docket number 2389. We think these objections have been cured with the additional disclosures relating to the treatment of opioid claims and how the opioid trusts are going to be structured, and then the further disclosures that are yet to come in the plan supplement filing process. And then beyond that, Your Honor, we think these objections were really just targeted at disclosures around those topics. So we think it'd be appropriate to overrule this one as well.
Mr. Anker, are you speaking on behalf of Covidian?
I am, Your Honor. Can you hear me okay?
Yes, thank you.
Okay. Your Honor, I'll try to be brief as well, maybe not quite as brief as Mr. Silverstein, but hopefully brief. I think, as Mr. Gott just noted, our objections are entirely disclosure objections. I appreciate, and we certainly reserve all rights as to confirmation, but I appreciate that courts don't like to hear confirmation objections at the disclosure statement hearing, and I'm not going to pretend that the plan is, quote, patently unconfirmable within the limited context of that law. With respect to disclosure, I guess my reaction is if this were the original plan that called for the filing of the plan supplement literally 5 days before the objection deadline and the voting deadline, I don't think the disclosure statement provides adequate disclosure, and I'm happy to say why. But I think that these are issues that can be cured, and I expect the debtor will cure through the plan supplement, which I gather now is going to be filed 35 to 6 weeks before. By way of example, there is a new class that was created yesterday under the plan. I say yesterday in the plan that got filed overnight, class 9I as in Irving, for no recovery opioid claims, which is defined as claims that are, and let me see if I can get the definition here right, Your Honor. Yeah, all opioid claims that are either A, subject to disallowance under section 502E1B of the Bankruptcy Code as of the effective date, subject, however, to section 502J of the code, And the definition goes on. Well, who is making that subject to disallowance? If it's Your Honor, I have no qualms, but who makes that decision and what does it mean subject to reconsideration under 502J for purposes of classification? On treatment, with respect to other opioid claims, which is the other class the claim might fall in, assuming it's not part of an assumed contract, there, if you look at the definition of what other opioid claims get, and this does go to disclosure, it says, quote, shall receive its pro rata share, each other opioid claim, quote, shall receive its pro rata share of the other opioid claim share up to blank percentage of the allowed amount of such claim. Well, clearly, to know what to do, that percentage has to be filled in. And even if you look at the definition of other opioid claim share, it is defined in a blank as well as a share to be determined in connection with confirmation potentially, and also must be acceptable to other holders, the Governmental Plaintiff Ad Hoc Committee and the MSGE group, who are not in fact parties to that, are not evidently in that class. All of that creates issues. Another issue by way of disclosure is that what is apparently allocated to the other opioid claims are, quote, a share, the unspecified share of, quote, the opioid MDT2 initial distributable value. But there's another provision of the plan that talks about for the opioid second or subsequent distribution, that may go in part to a reserve for other opioid claims. I'm not going to argue today that there needs to be rateable, fair treatment. What I do think is there needs to be disclosure on all of these issues to allow people to make reasonable decisions. I do think, in candor, that disclosure can occur in the plan supplement. I hope and I expect it will be made, and it will be made with clarity and not, a lot of provisions that are hard to reconcile. And I certainly am prepared, and Mr. Gott reached out to me, and I appreciate that. I'm certainly prepared, if we have questions, to get on the phone and see if we can at least understand the treatment, so we can then make a judgment what, if anything, we need to do when it comes to plan confirmation. So with that, Your Honor, we're not pressing the objection today on the understanding that there will be clarity on all of these issues in the plan supplement. Thank you, Your Honor. Happy to answer any questions if you have any.
Thank you, Mr. Anker. No questions. Mr. Gott, I assume the plan supplement will address all these issues through the TDPs, anything?
Yeah, Your Honor, I think between the plan supplement, but then also, I think fundamentally what we're grappling with are the difficulties associated with what are highly contingent and disputed claims of parties who may be asserting in Covidian's case, may be asserting indemnification rights, potentially contribution rights in the future. But the notion is, or the trouble is, and this goes to why we amended the plan along the lines Mr. Anker described. The fundamental problem is that we have provisions of the bankruptcy code to grapple with in figuring out how to deal with those claims. Section 509C provides for subordination of claims for contribution by co-debtors with the debtor to payment in full of the primary creditor on those claims. Section 502E1B, which provides that contingent claims for indemnification or contribution or reimbursement can be should be disallowed for so long as they are contingent. And so there are sort of necessary uncertainties built into any process dealing with potentially large and any large number of claims that are like those that we are dealing with here. And so what the plan proposes to do, and what we propose to do moving forward, is to make sure that those issues are resolved in connection with confirmation. And I think the plan supplement, will certainly address, how those claims that may be asserted in any of those buckets will be adjudicated or resolved or settled, however they may be treated. We do have, that we did amend the plan, or we revised the plan to, state more clearly that the other opioid claims are going to be adjudicated, resolved, liquidated, settled by the opioid MDT2 trustee, so the main trustee for the master distribution trust. And we think the disclosures around that process are appropriate. So understand Mr. Anker's concerns. Just wanted to make sure that the intention behind the plan and the provisions of the plan is clear, so that there weren't any misconceptions.
So, Your Honor, if I might, as Mr. Anker might be heard briefly, the last thing I'm going to ask is for the debtor to change the provisions of the bankruptcy code, and I don't want to get into ultimate plan objections. These are, I hope these claims never arise, frankly, at least in a liquidated way. There are provisions of the code 502J that provide, for reconsideration of a previously contingent claim, and lots of case law that provides for it, and for catch-up distributions if necessary. And there are lots of provisions that say, and I think as I read the disclosure statement, it now says that Your Honor, the issues can be brought to Your Honor post-confirmation, and Your Honor gets to decide about the allowability or non-allowability of those claims in accordance with the bankruptcy code and applicable law. And if it says that, that may be sufficient. I'm not going to get into plan confirmation issues now. I am committed to working with Mr. Gott, if it's not clear already, to make sure we have clarity so my client can make a judgment on what, if anything, it wants to do at this point. Hopefully that will be nothing.
All right. Thank you, Mr. Anker. So it sounds like these objections are not being pursued, so we will set those aside for now, and if they're not resolved at the time of confirmation, I'm assuming I'll hear from Mr. Anker again, but hopefully those get resolved.
Thank you, Your Honor.
All right.
Scott, next.
Yeah, next, Your Honor. So we have the UCC's objections, which we resolved. The UCC is one of the parties who we know would like to make a statement. As I mentioned at the outset, we'd like to save those for the end to try to get through as many objections this afternoon as we can to avoid the need for so many people to come back onto the hearing whenever it may reconvene. I know we're already down under 30 minutes left, so I imagine we'll be needing to reconvene. But so I just wanted to put a pin in and make it clear we understand the UCC will want to make a statement before we wrap.
Ms. Beckhart, is that okay with you to wait till the end?
Yes, Your Honor, if that's your preference, we would like to just explain some of the reasoning and the rationale behind the settlement that we made, and we'll save that for the end if it's appropriate.
Okay, thank you. All right, next up, Mr. Gott.
Yeah, so the next, actually the next objection that we have not resolved. So I'll note that on the chart, the next objection that shows a substantive response is the ad hoc committee of NAS children. We did hear from counsel to the ad hoc committee before the hearing started that their issues had been resolved and they would not be pressing any objections. So I think we can move on to the next one down the list. And that is.
Let me just ask if, let me just confirm that if someone from the ad hoc committee of NAS children wants to speak. Okay. Go ahead, Mr. Gott.
Sure. Next on the list is the objection filed by Columbia Casualty Company, docket number 2400. And I'll turn the podium to Mr. Christian to take us through that objection.
Thank you, Mr.
Christian?
Gott. Thank you, Your Honor. David Christian on behalf of Columbia Casualty Company. Are using the debtor's chart as a tool. The first item is that we complain that the disclosure statement didn't identify or adequately describe what was happening with insurance policies that might be assigned to the trust. Let me say that I appreciate Latham and Watkins and Mr. Gott in particular extending the amount of time that will be available between the filing of the plan supplement and the objection deadline. That solves my major problem of having time to review it and object if necessary before a confirmation hearing. I will just mention, and I know this has been touched on a little bit in your discussions with counsel for the state of West Virginia and just a minute ago with Mr. Anker, that we sort of assumed that a disclosure statement would include details about what assets, particularly significant, potentially significant assets, are being assigned to a trust before disclosure statements are approved as being adequate. That's the kind of information that if I were a voter, I might be very interested in. But that, of course, isn't my main concern. So I won't belabor the point. I'll just mention that this seems like the kind of information that rather than being in a plan supplement should be part of an approved disclosure statement. But having the additional time that's been provided certainly deals with the main concern of my client.
All right. So is your objection resolved, Mr. Christian, at this point? Are you gonna?
Well, I think that particular point on the chart is mostly resolved from my standpoint. And I heard what you said about the plan supplement earlier, and I'm not going to belabor the point about having that before the court approves the disclosure statement.
Okay. Is there another issue that is still outstanding?
Yeah, there are a couple more issues I'd like to talk about. The second item on the debtor's chart relates to the plan provision about the debtor negotiating with the trust to minimize adverse consequences of self-insured retentions. And we pointed out that we didn't know what that meant, and we posited in our objection a couple of things it might mean, some of which are on the pernicious end of the spectrum and some of which are pretty innocuous. And the debtor has proposed to amend the disclosure statement to require that self-insured retentions be paid to the extent required by applicable law. What that doesn't say is that the self-insured retentions are not impaired by the plan. And one of the things we've suggested to the debtor is that if it's the case that the plan provides that self-insured retentions that are below Columbia's policies may be impaired by the plan, we would take the position that limits the ability to access the insurance coverage that sits above those self-insured retentions. Now, that's our litigation position. The debtor doesn't have to agree with it, but it seems like an important disclosure to claimants that there may be valuable insurance assets that may or may not be part of the assets assigned to the trust to resolve their claims, and that the debtor's lack of provision or potential impairment of the self-insured retentions could limit or eliminate their ability to access those insurance proceeds. We've suggested language along that line. I don't know that the debtor's had a chance to fully consider it. I don't know the debtor's position on that language or that additional disclosure, but that's our view.
Okay, Mr. Gott.
Your Honor, on that specific point, that's right. I do know I have a proposal from Mr. Christian, and we will consider it. Of course, need to discuss it with our RSA parties as well. But I think from my understanding on reading that disclosure and then from hearing Mr. Christian, I'm sure we can work out the disclosure around that particular item.
It does sound like something that is easily fixed with a sentence or two.
Yes, Your Honor. One other thing, well, let me mention two other things just for the sake of good housekeeping. The debtor, I think, correctly indicates that we've resolved our disclosure objection related to the use of the trust of Rule 2004 after confirmation. There's, I think it's about 4 sentences that they've added to the disclosure statement that explains our view of that. There is also a plan modification that was included in the proposal from the debtor for resolving this objection. I may have missed it, but in the version of the plan that was filed just before this hearing, I did not see that additional plan provision, and I think that is an important piece of the puzzle to make to make the additional disclosure make sense or to make it true, that modification of the plan needs to be included as well. And so just for the sake of housekeeping, I'll mention that we think that's important. Our understanding is the debtor intends to include it. It just wasn't in the version I had served on me as this hearing was beginning.
Scott?
That's correct, Your Honor. I think we intend to address that. We intend to address that issue in the forthcoming revised version of the plan.
All right.
Thank you, Mr.
So it sounds like that's resolved.
Yes, Your Honor. One last point. It's number 4 on the debtor's chart of Columbia's objections. I think it's half resolved. It's listed as resolved in the latest version of the chart, but I'll say I think it's half resolved. And what I mean by that is this. Certainly the additional language in the disclosure statement explains that the way they're getting opioid policies into the trust, if they're executory, is through Section 365. If they're non-executory, I understand from this additional disclosure that they're going to rely on preemption under Section 1123A of the Bankruptcy Code. So we appreciate having that disclosure so we know sort of what we're dealing with. What it doesn't do is explain whether or not they're treating the opioid insurance policies as executory. And so we don't really know in what universe we're operating, and creditors don't know whether they're looking at an assumption and an assignment or they're looking at some preemption battle in the context of getting the policies into the trust. And I'll just mention for context that Columbia's issued a policy in 2016 that had a term from June of 2016 to June of 2017 that was renewed for another year from June of 2017 to June of 2018. And it would surprise me to learn the debtor, it would be unusual for the debtor to take the position that a liability policy with an expired term prior to the petition date under which all the premiums had been paid was an executory contract. That would be, given the state of the law, at least in the Third Circuit, would be a novel approach. But I think the disclosure statement should disclose, which of those avenues they're using to treat policies like Columbia's, and to make disclosure, depending on which it is, about any objection we might have to that.
Your Honor, so this topic is, I think, very clearly a something that's quite specific to Columbia or to insurers, which of course are very a small subset of our creditor base. It's also not something that affects distributions to any other creditors. It's not something that affects the value of the reorganized company. These just aren't the types of issues that need to be covered by a disclosure statement. And indeed, they will be covered, though, when it comes time to file the plan supplement and to disclose the executory contracts that we intend to assume and as applicable, assume and assign to the opioid trust. And we can have the disputes around whether a contract is executory or not, and whether we are operating under Section 365 or not, can play out from there and are appropriately addressed at confirmation. Sitting here today, I don't think there's any requirement contemplated under Section 1125 that we articulate. Excuse me, that we articulate the legal basis for every single contract assignment or assignment of rights that we may ultimately undertake, particularly when the schedules for again the assigned contracts and the assigned insurance policies will all be disclosed in the plan supplement, and so any disputes can take off from there.
Your Honor,
I agree. I think I agree. I think the issue is really one that is of interest only to Columbia and maybe some other insurance companies, and I think the issue is adequately disclosed at this point. To get into details about how and when and why they are, whether contracts are assumable or not assumable, and how they're going to be transferred to the trust, I think is something that is a confirmation issue, and I don't think it's required under 1125 for the debtors to disclose that.
Your Honor, may I just say one remark about Mr. Gott's rejoinder there?
Go ahead.
again, thank you, Your Honor. I don't want to belabor the point or the court's time. I do think it's more than our sort of parochial legal issue at confirmation. Just by way of example, and we mentioned this in our objection to the disclosure statement, the plan has a provision, and it's rather lengthy, about how if it's an executory contract under which somebody else might have a claim, that claim will be cut off and that the executory contract will be modified. And certainly if we're in a battle about whether that's permissible under Section 365, whether they've even properly characterized the policy as executory, and also whether it's assignable anyway, are things that could directly affect the rights or abilities of creditors to gain access to the proceeds of that policy. So I think it's not my fight to fight. My client isn't a voter on this plan, but I don't think it's true to say that it doesn't relate to the distributions that creditors might obtain from the proceeds of those policies.
Well, I don't think that changes my position. I think the plan, or excuse me, the disclosure statement does provide adequate information for a reasonable creditor to make a determination on as to whether or not the insurance proceeds will or will not be available, and if they want to vote for or against the plan based on that issue, I think they have sufficient information.
Very well, Your Honor. Thank you.
All right, we only have 10 minutes left, Mr. Gott. We still have a ways to go here, it looks like.
Yeah. We do.
I did reserve, I have time tomorrow. I had several hearings that have come off for tomorrow. So we can pick this up tomorrow morning at 10 a.m. And
that would be
how much
that would be fine for the debtors, Your Honor.
Your Honor.
Go ahead.
I'm sorry, Art Price for making Gumstrasser and Feld. We had alerted the debtors to this problem, and I believe they had alerted your chambers that there are a number of us who need to be in another hearing tomorrow at 10 a.m. for the companion opioid case that should be done by, I would say, hopefully 12:30 or so, 12 o'clock. So if at all possible, if we could start at 12 or 12:30, that would be great.
How much time do you think we have left, Mr. Gott? How many objections are remaining here?
So I would say we probably have a little less time than we just spent now on disclosure and confirmability issues specifically. So something more, something like an hour and a half if I had to wager. We also have the scheduling motion and some issues around discovery protocols that will also take up some time. So I think this will be, we probably still are looking at something to the tune of a few more hours.
Your Honor, this is Evan Jones from O'Melveny and Myers. Your Honor, just a point of personal privilege. There are other conflicts. I have a bankruptcy trustee who has just flown into LA tonight for an all-day meeting tomorrow that I'm hosting. We do have objections that we'd like to be heard. I understand that scheduling anything for a group this large becomes difficult, but we only heard from the debtor yesterday that they thought we might roll over into tomorrow. I can clear my day on Thursday. I don't know if that's convenient for the court or not.
I can't clear my day on Thursday.
Very well, Your Honor. I'll have a colleague present, and I apologize to the court for not being here tomorrow.
Okay. Well, I appreciate your ability to have a colleague deal with the issue. Is there anyone else who has an issue with tomorrow?
Your Honor, Albert Ciardi, we had the status conference on the trustee motion is also on at the end of the disclosure statement hearing for today. I don't know if that's one of the matters Mr. Gott had been mentioning that still needs to be addressed. We obviously can do that at another time, but it is on the list. So I don't have, I like the others are not available in the morning tomorrow, but I think our matter can be somewhat discreet and put on a different day.
All right. Well, I appreciate moving that off then. It'll free up some time. My day tomorrow, I'm having a live hearing for the first time in 15, 16 months tomorrow at 3 o'clock. So let's start at, Mr. Price, is 12 okay, or do you need 12:30?
I hesitate because Mr. Eckstein and Mr. McClay are both also speaking at the same hearing. So I don't know how long-winded we all will be, plus some other people, but what do you think, Mr. Eckstein, 12 or 12:30?
Your Honor, based upon this is Mr. Eckstein, based upon my experience in the other case, I would say 12:30 probably is the safer time, but I'm also mindful that you want to be able to conclude tomorrow. So we'll figure out how to handle either way, but I would appreciate starting at 12 or 12:30, and we'll join as quickly as we possibly can.
We'll start at 12:30. I guess the one good thing about having a live hearing is I can always make them wait in the hallway if we run over a little bit. So we'll start at 12:30. Hopefully we will get through at least the disclosure statement issues tomorrow. If we need to, I appreciate Mr. Ciardi's willingness to push off the other issue until later. We also have a discovery issue between that the debtors brought to me today that I told them I would hear at 11 o'clock tomorrow, but I guess that doesn't work either. Is that still a live issue, the discovery dispute?
And
I think
Your
Mr.
Honor,
Stern
this
sent me a little.
is Your Honor, Daniel Aston. On this issue, I believe Mr. Flowers, Pete Flowers, and I from Myers and Flowers, spoke this morning, and he reached out to Mr. Murtaugh. I believe that we have a rubric for resolving the issue that will not require the court's intervention. I don't know whether that loop has been closed, but that's what I have. Maybe if Mr. Murtaugh's on, he can speak to that issue.
Your Honor, are you on? Or Mr. Harris, somebody, whoever?
Yes, Your Honor. It's Chris Harris of Latham. If you can hear me, we have made a proposal to the ad hoc group. We have not yet heard back. Hopefully we can resolve this, but we would like to reserve the time tomorrow whenever is least inconvenient to the court in case we're not able to. So it is still live now, but we're hopeful we can resolve it.
Your Honor, Mr. Aston, my sense is that it'll be resolved. I am on an airplane in the middle afternoon at noon, but from what I saw from the proposal, I'm fairly optimistic that it'll be resolved and before we all retire for the evening.
All right, well, let's try to get it. I did tell the parties they could file something today by tomorrow, 10 o'clock in the morning. So I'll see if those come in at 10 o'clock tomorrow. If they don't, I'll assume their issue is resolved. If they do come in, we'll either hear it at the end of the disclosure statement hearing if we're able to get to it. If not, we'll have to push it to another day. I can do it late in the day on Thursday if necessary. But hopefully it gets resolved. So just let me know if it's resolved or not by tomorrow morning.
Will do, Judge. Thank you.
Your Honor, it's Bob Stern. If I may be heard for just a second, Richard's lighting a finger. We will endeavor to resolve this consensually. If we can't, we will let you know by email to Mr. Cavello in the morning, and we'll file our letter.
All right. Thank you, Mr. Stern. I appreciate that. All right. The other thing I wanted to mention, just for people to think about, is I see we have, based on the schedule you have for confirmation, you have this set for a one-day confirmation hearing. I don't know if we're going to have this done in one day, if all of these objections that I have to that are confirmation issues, that I've said are confirmation issues, go forward. So do we need to set this for a multiple day hearing, which if we need to, I'd rather do that now, because once my schedule fills up, then we might end up with, a day here, a day there. So if you want more than one day, if you want 2 or 3 days in a row, best to let me know now so we can get it on the schedule. Ms. Uramali, you raised your hand.
Your Honor, Anna Uramali of Latham and Watkins on behalf of the debtors. You read my mind. That was one of the things that I was going to raise when we addressed the scheduling motion, is that we do believe this will be a multiple day hearing, and that we would like to work with Your Honor and Chambers now to set those dates, ideally consecutively. But we did not want to presuppose or presume that the 21st worked for Your Honor. So we agreed to that date with all the parties. And when we address the scheduling motion, we're going to request dates that worked. But if we could coordinate that with Chambers tonight and have a timeline that we can present tomorrow, we're happy to do that.
All right, why don't we do that? And we'll talk about it tomorrow, but I'm assuming you're going to need at least 3 days, maybe more, for confirmation. So let's see if we can find a time when we can get it consecutively. I do see I have something on my calendar for the 23rd and 24th already. So, but that's something I might be able to change. All right, we'll talk about that tomorrow then.
Thank you, Your Honor.
And the other thing I'd ask the parties to consider is, do you want to do this hearing live for confirmation? Rather than avoiding some of these issues we have with the technology like we had this afternoon. But think about it. I'm not wedded to it one way or the other. If the parties want it and think it would be helpful, I'm happy to do it live. Otherwise, we'll do it virtually. Okay.
Understood.
All right. Well, thank you all. I'm a couple minutes late for my next appointment, so I need to jump off. But so we are adjourned until tomorrow at 12:30, and I will see everybody then.
Thank you, Your Honor.
Thank you.